Good afternoon. I trust we are all well and had a lovely week and looking forward to the weekend. It is Friday, and on a Friday I try to at least post a video in trying to conclude and summarize what events took place during the week. A lot has taken place during the week. And there were 3 webinars dealing with child custody, child maintenance and divorce. I would implore you to watch those videos. It's quite general and it deals with a general concept on how family law matters are resolved. So that is very useful. From my side, there's a lot of developments from the court's point of view. The courts are still operating half virtual and maybe half, in person, depending which court you are. If you might be in a different court, where that court might stipulate, no, we're only dealing with virtual matters, whereby you have to use Zoom or Teams. And some courts, they allow practitioners to appear in court, however, they limit the amount of people in court. So that's what the trend is these days. But nonetheless, we try to remain safe and at the same time, we try to prosper and move forward in life. Today's topic: when do you approach the court in family law matters? A very important topic, because many people believe they should go to court the moment a problem arises, and some people prefer to wait, where in fact they should have approached the court long ago. So let us deal with some extreme examples. If you are a victim of domestic violence, let's say your spouse is abusing you, hitting you, swearing at you, physically, emotionally, psychologically abusing you, whatever the case may be, then you do not have time to mediate and try to resolve the matter. This person has a problem, and you obviously have to, how can I say now, prevent it from happening in the future, protect yourself. And in that regard, you should approach the domestic violence court as soon as possible. Do not even go to a lawyer. That will delay the process. Of course, you can go to an attorney, an advocate, to assist you in the process. However, you should make a decision. I'm going to court, I need legal help immediately. There's no time for meetings and mediation and so on. So that's where I would advise you to go to court immediately if you are a victim of domestic violence. That's a family matter. Domestic violence, family issues, husband and wife, girlfriend and boyfriend, family, brother and sister, and so on. Another scenario where I would advise you to approach the court immediately would be in a child maintenance matter. If you and the other party, you are in agreement regarding the child maintenance amount, there are no issues, there's no need to go to court. However, the moment there is a dispute where you are not receiving adequate maintenance for your minor child, the person is refusing to pay maintenance, or the person decides to pay less than what is required, and there's a dispute, he might believe or she might believe what is being paid or received is too much or too little, whatever the case may be. Under those circumstances, I would advise you to approach a maintenance court ASAP in order to resolve that issue. So there is no delay regarding that. So we're dealing with the topic: when do you approach the court in family law matters? If you have any questions, feel free to pose it. I'll be online for the next 20 or so minutes, and hopefully I'll be able to assist you regarding this specific topic. When do I decide to delay approaching the court? Okay, so usually these type of scenarios would apply to care and contact issues, whereby one parent has care over the minor child and the other parent wants to have contact with the minor child, wants to see the minor child, wants to be in the minor child's life. So I would not want to be too general and say it's not possible to approach a court immediately. Under certain circumstances, it makes sense to approach a court immediately for care and contact issues. For example, let us say you looked after the minor child indefinitely for quite some time, and the other parent would have contact telephonically or maybe face-to-face now and again. All of a sudden, the other parent decides, no, I want to keep the child because I am the biological parent of the child, and you cannot now see the child. You had enough time. You had 5 years of the child's life. I want to exercise the 5 years. Under those circumstances, I would, of course, advise you to approach the court immediately in order for them to assist you in having the minor child returned. So those are extreme examples, like domestic violence. What I'm discussing now is when not to approach a court immediately if there's a dispute. You are exercising contact to your minor child, you are seeing the minor child, things are not out of the ordinary. However, now you like to have more contact. Or one parent might decide no, contact must be lessened. Under those circumstances, I would advise you not to immediately approach the court. Try to resolve the matter out of court firstly. Try maybe to mediate the matter, see a mediator, see a facilitator, a counselor, psychologist, whatever person who may be able to assist you in trying to resolve that specific issue. Because you are having contact, the other party knows you're having contact, the other party might decide contact is too much. But with proper mediation whereby you can voice your reasons, and the other party can voice his or her reasons for refusing it, and maybe the parties would come to some type of amicable resolution where the party holding the cards, or the one who has primary care, might say, you know what, I'm listening to your point of view. You know, the child is older, the child has spent more time with you, it makes more sense for you to have more contact. Also, at the same time, trying to avoid the parties from approaching the court in the first place. So, on a care contact issue, I would not advise the parties to approach the court immediately first out to resolve the matter. There may be care and contact issues whereby ultimately you would have to approach the court for a court order. However, it may be best to approach the court for the court order based upon an agreement entered into between the parties. For argument's sake, let's say one party wishes to relocate overseas and requires an order that he or she might have certain guardianship rights when the minor child is overseas. Consent is not required for traveling, for passport, and so on. And you require an order for that specific purposes. Yes, it's possible to have written consent, but that might be problematic in the future, whereby you may be overseas and they say, no, we want orders. Or some countries want to see orders. They don't like written agreements. So ultimately, you are going to court, but you first trying to resolve this matter between the parties. Come to some type of agreement on paper, a settlement agreement, taken to the office of the family advocate, they can endorse it, and you have that specific agreement be made in order of court. So that is where I'm looking for a scenario whereby you have to go to court, but we first try to resolve the matter before we go to court. So we go to court with a signed, agreed upon agreement. So we've dealt with child maintenance, domestic violence, urgent care and contact scenarios, the general care and contact situation whereby the parties can't come to an agreement, but they can go to mediation because things are not that hectic. However, should things become out of hand, please approach the court under those circumstances. Another scenario where you have to approach the court would be in a divorce matter. Parties cannot get divorced without a court granting a decree of divorce. You cannot sign divorce rights and expect to be divorced. You need to approach a court, and the court would have to grant a decree of divorce. So under those circumstances, you have to approach the court. However, as I mentioned earlier regarding the guardianship example, it is always best to have a divorce mediated or resolved before approaching the court. Basically, they call it a consent paper or settlement agreement, whereby the parties agree, you know, we are married income into a property. This is how we'll divide the joint estate. We have two minor children involved. This is how we will share care and contact. The child will remain with you for a few days, with me for a few days. School holidays will be shared. This is how we'll deal with birthdays, public holidays, special days, Christmas, even Muslim, Eid, and those specific, you know, situations that might arise in the future. Each parenting plan, each specific agreement is different. And this is how we will work out the child maintenance. Both of us are working. Therefore, when the minor child is with you, you care for the minor child, I care for the minor child, when the child is with me. However, school fees will cut in half, and you pay half and I pay half, and so on. So those are the type of things the party should agree upon before instituting divorce proceedings. You issue summons for the divorce. Yes, you have to do that, but with that summons, you ask for the court for a decree of divorce, and having the settlement agreement that the parties have entered into before that made an order of the honorable court. So things can be very quickly. You can get divorced within a period of a month or two, depending upon the court and its availability. We all know with COVID-19, courts are a bit economic on the amount of matters they are hearing on a daily basis. But nonetheless, you would be divorced in the next few months as opposed to a few years, should the parties decide to be acrimonious and decide to fight the issues applicable to the divorce. So those are the general scenarios in a family situation whereby you would approach the court, or you may not approach the court at the first instance. If, however, things are becoming very serious and hectic, and you require some type of urgent relief, of course, you need to approach a court as soon as possible, but it's always good to send it with a precursor, like a letter of demand or some type of documentation, in attempt to avoid going to court. With the recent, not too recent, but advent in the High Court rules, when you institute any proceedings, you have to inform the other party whether or not you would consent to mediation or not consent to mediation, and that will be filed in the court file as well. So the courts are now, the law is going towards the issue concerning mediation as opposed to approaching the court as a first resort. It should not necessarily be a last resort, but it should be something which you have thought upon before approaching the court. There we have it. The topic: when do you approach the family court in law matters? Number one, in summary, if it's urgent, like domestic violence, child maintenance, you approach the court immediately. If our matters where there are disputes, the disputes are serious, however, it may be better to resolve this matter out of court. It's possible to be resolved out of court, for example, additional care and contact, issues regarding the minor child's school, potential relocation issues. That's best to discuss, face to face with a professional mediator. Divorce matters, of course, under those circumstances, you need to approach a court for a divorce decree, and only a court can grant a decree of divorce. However, we obviously advise you to enter into the divorce proceedings with a settlement agreement, a consent paper, parenting plan entered into between the parties, so matters can be simply resolved. Thank you very much for watching this video. I hope you have a lovely weekend, and I'll see you online again soon.